Hi everyone, in this video we will discuss some important case laws on Indian Constitution. This is part 4. The first case is SP Gupta versus Union of India and others 1981. In the first judge's case, the Supreme Court was tasked with interpreting the meaning of the word consultation as used in Article 124 Clause 2 and Article 217 Clause 1 of the Constitution of India regarding the appointment of judges. By a majority of 4 to 1, the apex court held that the term consultation does not imply concurrence. However, it emphasized that the consultation with the Chief Justice of India must be meaningful and effective in the appointment of judges to the Supreme Court or High Courts. The Supreme Court rejected the notion that the CJI's opinion should hold primacy in the appointment process. It held that in the event of a disagreement, the ultimate power would rest with the Union government rather than the CJI. The next case is Supreme Court Advocates on Record Association versus Union of India 1993. The second judge's case led to the establishment of the collegium system in India. In a re-examination of the first judge's case, a 9-judge bench of the Supreme Court ruled by a majority of 7:2 that Articles 124 and 217 of the Constitution should be interpreted in a purposive and contextual manner. The court held that a collegium consisting of the Chief Justice of India and the two other senior-most judges of the Supreme Court should be responsible for proposing and appointing judges. Furthermore, the apex court held that in the event of a conflict between the President and the Chief Justice of India regarding the appointment of judges, the opinion of the Chief Justice of India would not only have primacy but would be decisive in the matter. The next case is in Re-Presidential Reference 1998. The third judge's case originated from a reference made by the President of India under Article 143 of the Constitution, seeking an advisory opinion from the Supreme Court. A 9-judge bench of the Supreme Court unanimously delivered an opinion that reaffirmed the judgment given in the second judge's case 1993. The primary change introduced by this reference was an increase in the number of judges in the collegium. In addition to the Chief Justice of India, the collegium would now comprise the 4 more senior-most judges of the Supreme Court. The Supreme Court Advocates on Association versus Union of India 2015. This case is popularly known as Fourth Judge's Case. The Constitution 99th Amendment Act 2014 and the NJAC Act 2014 were introduced with the intention of replacing the collegium system with the National Judicial Appointments Commission (NJAC). The NJAC would have consisted of the Chief Justice of India, 2 senior judges, the Law Minister, and 2 eminent personalities appointed by the Prime Minister, Leader of Opposition, and Chief Justice of India. However, the constitutional validity of the 99th Constitutional Amendment Act and the NJAC Act were challenged in the Supreme Court. In a constitution bench comprising 5 judges with a majority of 4:1, the Supreme Court declared that 99th Constitutional Amendment Act and the NJAC Act as unconstitutional. The court held that the formation of the NJAC would infringe upon judicial independence and violate the principle of separation of powers. The last case is Indira Sahni etc. versus Union of India and others 1992. This case was heard by a bench of 9 judges. The Supreme Court examined the extent of Article 16 Clause 4 of the Constitution, which allows for job reservations in favor of backward classes. It held that the term backward classes mentioned in Article 16 Clause 4 can only be identified based on caste and not economic conditions. Furthermore, the court upheld the constitutional validity of a 27% reservation for other backward classes, OBCs, but imposed certain conditions. This case introduced several key principles, including the proposition of a 50% threshold for reservations, the prohibition for reservation in certain types of positions, and the exclusion of the creamy layer from the reservation benefits. That's all for the day. Thank you.